Good morning and welcome to Copyright Basics for Librarians. My name is Karen Kitchens. I'm the Intellectual Property Librarian here at the Wyoming State Library, which means that I run the Patent and Trademark Resource Center. I also do the Federal Depository and Reference. The impetus for conducting this webinar, I need to let everyone know that we've had a couple questions from librarians across the state regarding copyright. And so it came into my mind that maybe we needed to do a short webinar on copyright basics. And apparently we do. We had a number of attendees and I really appreciate that. I don't claim to be an expert, but I did really feel that there was a big need. Copyright is a very complex area. There's lots of information to cover, and I apologize because I really thought the best way to do this was just put the information out in a PowerPoint, although we will go and look at a couple sites. There's lots of information to cover, and I will take questions at the end. Oh, there we go. All right, right off the bat, I'm a librarian. I am not an attorney, so any information that I present is strictly for information purposes only. So let's get started. Here's what we're going to look at today. We're going to look at law and guidelines, an overview of. It's not a comprehensive list. The exclusive rights afforded copyright owners, the scope and protection of copyright ownership, how long do copyrights actually last? We're going to look at some exceptions and limitations, including public domain, fair use, reproduction by libraries and archives, and educational material. We'll touch a bit on the Digital Millennial Copyright Act and the Technology, Education, and Copyright Harmonization Act. These are two acts that affect librarians and educators specifically. I'll talk very briefly about software copyright and how to obtain copyright permission, and we'll look at the Copyright Clearance Center real quick. Copyright is a form of protection grounded in the U.S. Constitution and granted by law for original works of authorship, fixed in a tangible medium. It balances the rights of authors, publishers, and copyright owners with our need for free exchange of ideas. Copyright law is codified in Title 17 of the U.S. Code. Here's a short timeline of copyright law and guidelines. I'm not going to read through all of them, but if you notice the 1909 revision of Copyright Act, under this provision, the federal statutory copyright protection attached to original works only when those works were 1, published, and 2, had a notice of copyright affixed. And also notice that it went for 28 years plus 28 years renewal. And that is no longer valid, and we'll talk about that a bit later. Number 4 extends, the revision of Copyright Act extends to unpublished works, so that reversed the 1909 revision where the work needed to be published. A few more that brings us up to date. We'll talk more extensively within the program of the last two, the Digital Millennial Copyright Act and the Technology, Education, and Harmonization Act, which really expanded the scope of materials that can be used in distance education. Okay, now to the meat of it, copyrights. What does a copyright owner gain? As a copyright owner, one can reproduce a copyrighted work, prepare derivative works based on the copyrighted work, distribute copies for sale, perform the work publicly, or display the work publicly for a prescribed amount of time. It doesn't last forever. What is protected by copyright? This is merely a list of possible works. It's not all-encompassing, and as you can see, copyright protects a whole wide variety of different works. The definition of what is protected by copyright is not a list of works like I have here. What it really is a criterion which works must fit to be considered under copyright protection. Two main features. It needs to be original, which implies some degree of creativity, although copyright protection can apply to a new work that is built on an existing work, but the copyright protection will only be applied to the added creativity. It is automatic the minute the work is put into fixed form. So the minute, if you are an author, the minute you write it down, that is in a fixed form. And no, you do not need to have a copyright symbol for it to be under copyright protection. And I actually just did have a reference question about that. What does copyright not protect? All these various things, and I have a couple examples. If you look at number 1, facts. Facts are not under copyright protection. However, as librarians, we might think of some nonfiction books that we have. A book, for example, about rare coins is protectable, but the stated market value of each coin within it is not. Another example might be the Bible, that is actually in the public domain. However, copyright may exist for various translations or formations of that work. As a government documents librarian, the second to the last one, works prepared by federal government, I do know that it may be original and it may be fixed, but it's still not copyrightable, and that is according to Section 105 of Title 17. But projects within a government publication that are done by non-governmental entities may be eligible for copyright. And we'll look at public domain a bit later. Copyright term. Copyright term is covered under U.S. Code, these various sections 301 to 305. And this says, how long does it actually last? There is by no means an exact term of coverage. Within Title 17, there are numerous qualifying factors, but I put down some real basic ones here. That works basically after 1978 are life plus 70 years. If it's a joint work, then it's 70 years after the last surviving author passes. So works published before 1978 and after 1923 are protected up to 95 years. And there's a really excellent, I wanted to show you, Cornell University has done an excellent term chart, and we'll go to that real quick and I can show you exactly how extensive these terms can be. And that is linked off my PowerPoint, or you can just do Cornell University copyright term, and you can see that there's lots of different qualifiers, and it just goes all the way down. They even have a nice PDF version. So if you really want an extensive list of copyright term, I would encourage you to go to this, and it was updated January 2012, so it's very current. Okay. Exceptions and limitations. Having said all that about copyright term, there are exceptions and limitations, and that's good for us as librarians. We're going to look at some of these. Talk about particularly public domain, fair use, exceptions within the statutes for libraries and archives, and educational exceptions. And you'll see the various corresponding statutes there listed below for these exceptions. start with public domain. Public domain is anything that's openly available to everyone and not subject to copyright protection. As a general rule, most works enter the public domain because of old age, so they simply expire. Or it could be that a work, for whatever reason, failed to meet the copyright requirements. That is technically considered public domain. An author may deliberately place their documents within the public domain using the Creative Commons, and we'll take a quick look at that. And of course, anything that's federal documents. A general rule might be anything published before 1923. So, a really good place to start if you're looking for content for use of freely and legally is the Creative Commons. And I'll bring up that site. This is a really cool site if you're looking for content. Basically what the Creative Commons is, it's a directory, it's actually a way for authors to put their works in the public domain, and it is very extensive. It's a licensing agency, so if you need something you can go here. So these works are in copyright, under copyright protection, but they're given out freely use. So copyright, Creative Commons. It's a nonprofit organization that enables sharing and use of copyrighted works for free. Moving on from public domain, we're going to talk about fair use. Unlike public domain, things that are in the public domain, not talking about the Creative Commons stuff, but anything that's in the public domain beyond that, these works are under copyright protection. They are not freely available to everyone. Did not want to do that. There we go. There's my little guy to remind me to tell you that if there's nothing else that you remember from this presentation, please remember fair use and 4 factors. And if that's all you remember, those words, fair use and 4 factors, you can look them up and review them. This is very important for us as librarians about fair use and what constitutes fair use. Within the statute, there are 4 factors to determine what can be fair use. So the first one, purpose. So a copyright's purpose is really to advance learning by providing incentive to creators of new works. Okay. So uses of works in educational settings are fairer than uses in non-educational settings. Non-profit educational uses are favored over for-profit, but most fall somewhere in between. The nature of the work, these are 2 aspects of the nature of the work used, whether it's unpublished or published, whether it's whether it's fictional or factual in nature. Use of an unpublished work can have a negative impact on a right holder's ability to financially benefit from that work. So works that are fictional have a stronger copyright protection layer, and because they're simply considered more creative. The amount, small portions are favored over large chunks. The effect, what must be considered is the detrimental impact of the unauthorized use of a work may have on the market value of the work. If the work is obscure or not commercially viable or available, unauthorized use has less of an impact, but no single factor is determinative. All 4 factors will be weighed and balanced. Some factors, for example, the first one in particular, are more important than others. The character of the use under the first factor affects the weight given the third and the fourth. As you may notice, in this statute, it's really rather vague. It's not telling us 2 copies versus 3 copies, etc. There's no hard and fast rule on what constitutes fair use, and that's what I want you to remember. There's no hard and fast rule. Only general rules and varied court decisions. Lawmakers and judges want fair use to be expansive for that very reason, to enable us to use it and apply it to various degrees. Okay, so having said all that, in 1976, Congress urged educators, librarians, and other interested parties to negotiate a shared understanding of fair use to help alleviate some of the difficulty over this ambiguity. However, please remember that these are guidelines that we're going to talk about by this put forth by this ad hoc committee. They are not in copyright law. Only a court of law makes the final determination on fair use. Remember, fair use, 4 factors. So here's some guidelines from this ad hoc committee that you might keep in mind. Single copying for teachers at your school, 1 chapter from a book, 1 article from a periodical or newspaper, a chart, graph, diagram, or picture or cartoon from a book, periodical, or newspaper. Multiple copies. Multiple copies need to meet the test of brevity, spontaneity, and cumulative effect to meet these guidelines, not law. And this comes from Copyright Circular 21 from the U.S. Copyright Office. They have a host of circulars posted on the U.S. Copyright Office website that are very, very informative. Remember, these are guidelines. None of these conditions are found in Title 17 of the U.S. Code. We'll look real quickly at each one of these: brevity, spontaneity, and cumulative effect. Now, these guidelines actually do list specific numbers. But remember, you can always fall back on fair use. Number 1, a complete poem that's less than 250 words, or printed on not more than 2 pages, or a longer poem but just not more than 250 words. Special works should not be reproduced in their entirety, even if it's 2,500 words. Fair use guidelines, the spontaneity. So really what this is saying is a teacher needs to do the copying, and they need to do it so close to the time that they need it that it would be unreasonable to expect a timely reply to a request for permission. Guidelines, again, not law. Cumulative effect, the copying of the material for only 1 course in the school in which the copies are made. Not more than 1 short poem, article, story, essay, or 2 excerpts may be copied from the same author, nor more than 3 from the same collective work or periodical volume during 1 class term. Not more than 9 instances of such multiple copying for 1 course during a class term. And the exemption being current news, periodicals, and newspapers, and current news sections of other periodicals. So what's prohibited by these guidelines, not law? Basically it's saying if you find any of these to be true, you may need to really evaluate the need for purchasing the item. So if you're constantly, or one of your teachers are constantly copying from a consumable work, which would include a workbook, exercises or test forms, answer sheets, etc., then maybe we need to look at purchasing them. Okay, we're leaving guidelines and now we're going to be talking about law. And we're moving from fair use to what's actually in the statutes for exemptions for libraries and archives. Title 17, Section 109A, first off talks about the first sale doctrine, and this is what enables us to lend our books and our other resources to patrons and other libraries. However, this does not apply to computer programs embodied to a particular machine. We can link computer programs, and we'll briefly touch on software later in the presentation. So here's some limitations listed in Statute 17, Section 108. So we can make no more than one copy or phonorecord, and that's the wording within the statute, and that really means anything that captures sound. We can make it for any purpose, made without any purpose of direct or indirect commercial advantage, so it really needs to be not for profit, needs to be open to the public, and it needs to include a copyright notice that appears on the copy. Or if we can't find the copyright, we need to put a notice that the work may be protected by copyright if we can't find the copyright for it. And that's for one copy. Okay, 3 copies of an unpublished work. As libraries and archives, we can make 3 copies of an unpublished work if we have a copy already in our collection and the copy is in digital format that is not otherwise distributed in that same format, and the copy is not made available to the public in the format outside the library or archives. Three copies of a published work. As a librarian and archives, we can make 3 copies of a published work if it's solely for purpose of replacement. So say we have an item in our collection, it's damaged, deteriorated, lost, or stolen, or if the existing format is obsolete. And obsolete is a format considered if the machine or device necessary to render it perceptible is no longer manufactured. So it might be like if we have something, I'm thinking like a floppy disk or something like that, we can't reasonably make that available or find something to play that, then we can make a replacement copy. Section 108 also talks about interlibrary loan. And we know that this is a request made from another library or archives for a copyrighted collection. And we can make that loan if the copy becomes the property of the user for private study, scholarship, or research. And there is a warning of copyright displayed prominently on the order form. Or the place where the orders are accepted might be another alternative. This is not within the statute, but in 1978, the National Commission on New Technology Uses of Copyrighted Works came up with these guidelines. And these are guidelines that a number of libraries adhere to. These might be what you call the rule of 5. Materials, we can loan materials that are less than 5 years old, less than or greater than 5 articles from one periodical per year, and it has to have a copyright compliance statement on it, or 6 or less copies of an article chapter can be made from a non-periodical. As I stated, these are guidelines and you're not required by law to follow them. Okay, now let's talk about educational exceptions. In the educational setting, there are numerous things that teachers can do to use copyrighted material within their classroom. And we'll talk about the educational exceptions in face-to-face instruction. Musical materials guidelines, they're a little bit different. And then we'll talk about the Digital Millennial Copyright Act and the Technology Education Copyright Harmonization Act. We'll talk about digital education, which is becoming vastly a big part of our education system, and software. Face-to-face instruction. For use to be included in this context, the following criteria needs to be met. So within this context, there's quite a lot of material that can be used, displayed, or performed within the classroom. And this is applicable to the traditional classroom setting. Okay, one teacher within the room, and the students are in the room at the same time. This is under Title 17, Section 1110. So that is not a guideline, it's actually the law. Musical materials, however, can come under a little bit different area. Playing music in the classroom are public performances and are excused by Section 1110. However, other uses of musical works or copying music onto new formats usually require a fair use analysis. So using music materials are not as freely allowed under educational exception. So we need to use fair use to evaluate them. In 1976, the Ad Hoc Committee on Copyright Law came up with some guidelines that might help us determine what can be used for music materials within the classroom. And here are some. Emergency copying of a single or multiple item which are not available for performance. Imminent performance, provided the purchased copies will be substituted in due course. Single or multiple copies of excerpts in no case more than 10% of the whole work for academic purposes other than performance, so long as they do not comprise a performable unit. The Digital Millennial Copyright Act is law and not guidelines. This landmark legislation updated the U.S. copyright law to meet the demands of the digital age and to conform U.S. law to the requirements of the World Intellectual Property Organization. Here are some things that it did, and we'll talk about each one of these. There are 5 titles in this act, and we are going to review 3 titles which primarily affect libraries and archives. Title 1. This gets rather complicated. Anti-circumvention rulemakings by the U.S. Copyright Office have taken place every 3 years since 1999. So even though Title I prohibits the circumvention of protection technologies, there are a few classes of works that are exempt. One being people with print disabilities are allowed to circumvent technology on e-books that prevent text-to-speech function. This is really getting into the area of law. And it also allows the circumvention of content scrambling systems on DVDs to allow the creation of clip compilations that a teacher might use, say, in their classroom, which might not fall under the educational exemptions. The Digital Millennial Copyright Act says that libraries, nonprofit organizations, archives, and such educational institutions, that we can circumvent to review in good faith for the purpose of determining purchase these protective circumvention of protective technologies. However, a word of caution. There are numerous qualifiers and there are serious penalties for misapplication. And in fact, many vendors will allow us to review a sampling of something that we might purchase from them, or short-term access to a commercial databases. So it may be best to go that route and not try and circumvent any protection technologies, even though we're allowed to under this title. Title 2. This exempts any online service provider or carrier of digital information from copyright liability of content by a user. So that includes libraries. So if we have a computer center, we are not liable for any copyright infringement that the user may do, or any information that they might store on their computer, as long as we remove or disable access to the infringing material identified in a formal notice by the copyright holder. So we need to expeditiously remove or disable access to the infringing material. Title 4. This authorizes institutions to make up to 3 digital preservation copies of an eligible copyrighted work. Eligible meaning a copy of a work that is currently in our collection, and any copy that is reproduced in a digital format is not otherwise distributed in that format and is not made available to the public outside the premises of the library. And obsolete, again, remember our definition of obsolete. And we can no longer reasonably find a device able to render that a specific format. Second act that we're going to look at, this was signed into law November the 2nd, 2002, the Technology, Education, and Copyright Harmonization, or the TEACH Act. Remember, previous exemptions focused on face-to-face classroom instruction. This act focused on distance education. And as we all know, distance education continues to grow. The TEACH Act. There are several requirements for compliance under the TEACH Act. It needs to be, of course, an accredited nonprofit educational institution or a governmental body. It needs to occur under the actual supervision of an instructor. And technological measures must be used to limit access. So specific students in a specific class, and what comes to mind is something like a Blackboard, where you can only log into your class. Computer software. Most computer software is licensed. It is not copyrighted. You need to read your agreements fully and carefully, and read all the terms and conditions, because within those terms and conditions may be that you cannot rent or lend that software. Remember, software piracy is a felony. Title 17, Section 109 covers lending software to patrons. It is allowed if we have obtained the software lawfully, if it's for nonprofit purposes, we have a required warning on the work, and our licensing agreement permits it. As libraries or archives, we can make one archival copy if we meet the following criteria. Once possession of the original software ceases to be lawful, then we must destroy the archival copy or transfer along with the original. And we need to have a copyright notice attached. So that's Title 17, Section 117, that allows us to make an archival copy. If you have any questions, or uncertain, you need to ask permission for using something that you might think would be under copyright and that might not fall under any of these exemptions. The place to start is the U.S. Copyright Office. Read through Circular 22, and it gives directions on how to find or hunt down a copyright owner. You would then send written permission, and if you're unable to locate the owner, you can use a limited amount. You need to weigh the cost benefit. Or you could use an alternative material looking at the Creative Commons, and we need to decide, is it really worth using the material? Is it worth the risk? Remember, fair use. The Copyright Clearance Center negotiates licensing terms and secures licensing fees and royalties. So this is primarily for corporate and academic users. So the Copyright Clearance Center might be something that you look at for your institution, and it provides collective licensing. It represents the copyright owner and serves as agents for multiple copyright owners. That is the end of my presentation. If anyone has any questions, here's my contact information. And I wanted to give you real quick a list of sources that I used. I'll go back to. Are there any questions? I hope this was helpful for you. Like I said, it was a basic just basic rundown on copyright. Please remember fair use and the 4 factors, because everything pretty much comes down to that, including if you are an academic library, e-reserves, reserves, or packets made for teachers.